So these are another example on the dispute between state list and federal list. So you can look it up and have a go, have a read on this. How judge specify the how judge give verdict on this dispute between state list and um, federal list. So which one is higher? Is it a federal law or state law? So if any state law is inconsistent with the federal law based on Article 75 of the Constitution, the federal law shall prevail and the state law shall, to the extent of inconsistency, be void. So if the state law inconsistent with the federal law, the state law, the federal law will prevail, provided that the law is based on the federal and state list. So if it was under federal list, and totally the state law will be void. But if it is not within the list but inconsistent, then the federal law shall prevail. So this is a law of Malaysia. So based on content, uh, based on sources, and based on enforcement. So as you can see, based on content here, substantive law. Substantive law is basically a law on the person, the subject itself. If it is a male, female, um, people of this state. And procedural law is how the law being enacted. How the for example, for example, you have when police take a person into custody. So there is law, there is tahanan remand, and how tahanan remand can be extended, and how much there is a procedure lah. So the procedure belong under the procedural law, and also international law. So we can gonna look on each of these type of law. Substantive law concerns with the determination of rights and legal powers based on the subject, a person, or and also on its legal power, for example, the minister, prime minister, a judge. And then the procedural law concerns with the legal operations by which these rights and power are discovered. So how they are being carried out. So there is a procedural law. There's a procedure for you to for a lawyer to put out a plea, for example. Uh, substantive law is the statutory or written law that governs the rights and obligations of those who are subject to it. So the person, or any body, a body of corporation, for example. So it defines the legal relationship of people with other people or between them and the state. This is substantive law. So, for example, people in the contract. So substantive law define that a client is the paymaster and main contractor is the one that carry out the work. So it defines each subject in the law, in the contract, and then the relationship. So it refers to public and private law. Public law is the common law. You kill somebody, so there's a relationship between the killers. And then the private law is a contract. Some of substantive law was derived from principle found in judicial decision or common law. So if there is a precedence hearings, precedence case, and then the judge has come up with a verdict, so that verdict can become a derivation for substantive law. So, and any case that is similar to that can be used as a ruling lah. So procedural law comprises the rule by which the court hears and determines what happens in civil lawsuit and criminal proceedings. So how the law being uh, administered, the procedure, and then the rules are designed to ensure a fair and consistent application to all cases. And for example, a time allowed for one party to sue another. So there is a time frame for you to sue. It's not like after like 50 years, then only you want to sue it, and that is not allowed by the procedural law. And then the next example is the rules of law governing the process of lawsuit. So how the lawsuit is being handled. So there will be a hearing first, then there will be a checking on evidence, for example. Then there's rules. Huh? Next is a based on enforcement. When you enforce a law, so that is a public law. So you want to enforce a law. For example, um, you cannot carry a drugs heavier more than uh, more than a kg, for example. So that is a enforcement. Public law is a branch of the law which is concerned with the relationship between governmental divisions, organizations of the government, and relationship between individual and the state. So between the government, between the state and the individual. So under public law, there's a constitution, the big law, the first law, and then the criminal law, where there's a wrongful act or criminal guilty mind. So you want to avoid any criminal breach or murder, cheating, any bad things to happen. You want to uphold justice. Huh? And then private law. Private law is the branch that the law which is concerned with the legal relations between private individuals as distinct from public law. So there is a if there is a dispute between you and your friends, so that falls under private law. There's a contract between you and friends. There's a private law. So basically, if you dispute, it falls under thoughts. We're gonna talk more on thoughts later on because it concerns with the construction industry. So there's a contracts. Contracts also concerns us in the construction industry, civil engineering tech. So contract based on arguments between two parties. For example, the PWD contract, PAM contract, is contract lah. Next is the international law. So international law is a body of rules and principle law, basically law, governing relations between between nations, international, between Malaysia, China, between Malaysia and Singapore. Since these rules could not be enforced by any definite supranational, international level, agency, their validity has long depended on the extent to which any particular nation chose to recognize them. In this case, some of the nations recognize ICC, International Criminal Court, and some of it doesn't recognize ICC. So enforcing the law will be a bit difficult. Topics covered in international law, treaties. There's agreement between two countries, nations. Jurisdiction, the power of the state to make and enforce its laws at the international level. The power of the state, this jurisdiction, basically to enforce a law and make the law and enforce law at the international level. This is covered international law. And then state responsibility for wrongful acts, for example, in the Israel or in the Russia, which being debated on the wrongful acts. And then human rights, there's a country violate the human rights, for example, in Myanmar. And then war and peace. Uh, International law and the public law. Public international law is the main part, corpus of legal rules applying between sovereign state. It deals with relationship between the states. There's a public international law. It falls under the public law, but internationally. So basically, like a public law internationally, legal rules such as law of sea on the international waters. What is the law there? International criminal law, international humanitarian law. On international private international law is the body of rights and duties of citizens of different sovereign states towards one another. It deals with that branch of the law that applies to individuals or legal entities involved in legal disputes of an international nature. So, if the private international law is basically on the private law, which is on of the international level. There's a contracts between, for example, company, Malaysian company, and international company. So, it fall under private law, private international law. Private international law, also known as municipal law. So every country may have its own version of law, and it covers on civil or human rights, negligence, contracts. So basically, private law, but on the international level, not only between the government and its own citizens, but also in how its citizens are treated by other nations. Alright, guys. So next is the law per sources. So the term sources of law, according to one noun in the Malaysian legal system, the term sources of law has several meanings. So the first one is historical sources, which indicate the factors that have been influential in the development of law, but by themselves not recognized as law. So it is in the community, in the culture, but not being written, such as the religious practices and beliefs, the local custom, adat, and an opinion of the juries. So it may also refer to places where the law can be found, as for example in statutes, law reports, textbooks, and decision of court. So there is a source, but it is not written in the form of official law, but can be a decision of courts, can be there's a law report on that. So it becomes a law based on the sources. So in most cases, however, it refers to legal sources. That is the legal rules that make up the law. So basically the decision of courts. So legal sources, there is written law, unwritten law, and then Sharia law. So these are all sources for legal. So written law is uh, federal constitution, constitutes of the states, undang-undang negeri, legislation, subsidiary legislation, undang-undang kecil. Then you have unwritten law, which is English law or judicial decisions, not written but based on the decision of the courts. And then customary law, undang-undang adat. And then last one is Sharia law. So in Sharia law only applies to Muslim. Is governed by the state because it falls under the state table, jadual negeri, bidang kuasa negeri, within the power of the state. So it is a sacred law of Islam revealed by the Prophet Muhammad sallallahu alaihi wasallam. It is totally based on God's commands on duties towards Allah and relationship of one Muslim with another. So main source of Sharia law is four, uh, two main sources and two secondary sources. So the two main sources are Al-Quran, the words of Allah, and then Sunnah, the rules deduced from the tradition, basically what the Prophet did and what the Prophet said becomes a Sunnah. So it becomes a source of law. Then the secondary sources, ijma, a consensus among jurists or scholars or of Imam in Islam. So there's a consensus and it becomes law. And also there's a qiyas, where make a deduction from reasoning, where based on the um, reasoning from either from the source of Al-Quran, Sunnah, and so from based on the logic thinking, so it becomes the Imams make deductions and it becomes qiyas. This is come out by the prominent scholar of Islam, and then in the manners of ijtihad or analogy. So these are some brief explanations of each of the sources. Four sources of Sharia law. It's the Quran, it's the book from God, from Allah, and a Sunnah from the narrations of the Prophet, from the Prophet, his acts, his saying, and whatever have been approved, and then reports from the Sahaba, from his Sahabat friends, and then Ijma, which refers to consensus, as mentioned before, and then Ijtihad. So, based on Article 3 of Federal Constitution, Article 3 states that Islam is the religion of the Federation. So, uh, the official religion for the Federation of Malaysia is Islam, but other religions may be practiced in peace and harmony in any part of the Federation. And court that will enforce Islamic law are the Sharia law. The Sharia law for matters such as family matters, marriage, and divorce.